Forum Malaysia dan Statut Rome diadakan rentetan pendedahan rumusan eksekutif Statut Rome kepada Majlis Saja-Raja oleh sekumpulan anak muda pada 7 April lepas.
At the outset, it must be kept in mind that the Cabinet had on 18th of March 2011 decided that Malaysia should accede to the Rome Statute. Although 8 years have passed and that decision was never revoked, it was not implemented either. Hence, when the Pakatan government decided to accept Rome, it was merely continuing a policy decision previously taken by the previous government. So the hypocrisy that surrounds this debate must be flashed out, which is that the critics of today were supporting the same decision yesterday. So this was an all-party decision of 8 years ago, but obviously some people have changed their mind. Unfortunately, some of the discussion, in fact the first 5 minutes will be terribly technical, so I seek your indulgence. This is to some extent a heavy legal subject. I cannot do justice without touching on the law. And Article 1 reminds everybody of the jurisdiction of the court, which is, it shall have the power to exercise its jurisdiction over persons for the most serious crimes of international concern. So it is most serious crimes of international concern. And that is elaborated in Article 5. So I now turn to Article 5, and that says, the jurisdiction of the court shall be limited to the most serious crimes of concern to the international community as a whole. So in fact, they tighten it a bit more because it's now the international community as a whole as opposed to a regional concern. It must be the entire global community who are upset. And then in Article 5, they set out 4 crimes which come under Rome. And that is very important to remember, that there are only 4 crimes or offenses that come under the jurisdiction of Rome. And what are they? First, the crime of genocide. And then crimes against humanity. Thirdly, war crimes. And finally, the crime of aggression. Now, if I just state those, you will know immediately, anybody with half a brain will be aware that we are talking of the most serious crimes of the world. So what that means, if you look at those definitions, is 3 points you can make immediately. First of all, as I alluded just now, domestic crimes are not applicable. So if there is a murder or a kidnapping or a rape that may be happening at this moment somewhere in Malaysia, the Rome Statute is not triggered. So what that happens is the police catch the accused, the perpetrator, for a murder that's happening at this moment. That person is remanded. The investigations are done by the police, and then he's charged by the public prosecutor under the ordinary criminal laws of Malaysia in the ordinary criminal courts of Malaysia. So there is nothing to do with Rome. And then secondly, even when we talk about international crimes, as I said before, it must be of the most serious concern which affects the entire community. And as I said, it's been narrowed down to 4. And those 4 crimes, you just look at it, you know it's horrific, it's terrible, it's most foul. And obviously the international community must be against it. So therefore, it is absolutely clear that the ICC has a very narrow and limited jurisdiction. And then you apply that to Malaysia and you ask ourselves, I say that because we look at Germany, let's take Germany as an example. Germany, in the run-up to the Second World War, during the Hitler's 13-year, the Third Reich, 13 years, and in the, say from over 35-36, you could see the violence that the state was sponsoring, and of course leading to the Second World War and the concentration camps. Now, if you ask that, if you compare German's history for 13 years with Malaysia's history, with Malaya's history, the closest parallel maybe for a few years under the Japanese occupation in the Second World War, those who lived here They may say it may border to some extent, but that was a foreign invasion. But throughout the time when Malaysia was independent and run up to Merdeka, we've always been a peaceful country. So these crimes have got absolutely no connection to Malaysia. And in fact, these offences do not exist on our statute books. These are not crimes under our laws. And they are not crimes under our laws because all the parliaments before the 14th parliament and all my predecessors in office did not require it to be legislated because there was no need for Malaysian laws on non-existent crimes in Malaysia. And so if we stop there, now I can go back and sit down and say, what was all the fuss about Rome for? What was the fuss? It just absolutely ridiculous. Then I just want to deal with two other issues quickly. One is there is a principle of complementarity, which means the ICC jurisdiction, if we had become a member, would only be triggered when either the Malaysian police do not investigate or the Malaysian public prosecutor does not charge. If the Malaysian prosecutor, if there is a genocide happening in Malaysia after we join Rome, if a genocide occurs in Malaysia, and if the Malaysian public prosecutor charges Mr. X or Mr. Y for genocide in the courts of Malaysia, that is the end of the matter. So ICC is in a sense a backup. ICC only operates if the Malaysian courts do not do their job. So in a sense, if we join Rome, there is a bit of pressure on those who administer justice to do the right thing, because if they don't do the right thing, then the international bodies can come in. So I think that's a good point. And then likewise, if we join, then we will not be a safe haven for the rogues on the rogues gallery. So I give you the best example. One of those who are wanted on the ICC list is Omar al-Bashir of Sudan, the dictator who was there for 35 years and he's been wanted for war crimes. He's just been overthrown, as you know, in a coup d'etat, in military coup in Sudan. But the Sudanese are going to say, well, they're claiming now that they will try him under Sudan law, which is good. If they try him under Sudan law, then ICC is not triggered. But anyway, I don't think Sudan is a member of ICC. But the reason I give that example is, if we do not join Rome, people like Omar al-Bashir and of course Robert Mugabe, they can come and visit Malaysia, knowing we are a safe haven. But once we join ICC, then they will be extradited immediately. We will not be attractive anymore. And finally, any jurisdiction that Rome would have if Malaysia joins is prospective. So let's say if we are joined on the 1st of July 2019, all crimes that only occur after that would be brought up. So all past crimes. So let's assume for a minute that there were terrible genocides happening in Malaysia that none of us knew about, or Malaysia took part in a war crime that we didn't know about before 1st July 2019. They also can't be charged. So it's a prospective position. So when the position is so clear, how did these fake news people confuse the public? And that is by falsely talking about the immunity of the rulers. So I have to deal with the immunity of rulers in the next 5 minutes. Now, the young di-Pertuan Agong is a constitutional monarch who must act on the advice of the elected prime minister, who represents the democratic will of the majority of voters. So, for example, if war is declared, although the Agong is the supreme commander of our armed forces, the decision to go to war is always made by the Prime Minister, the Cabinet, and the Minister of Defense. And operationally, it will be the generals who run the war, or the admirals if there's a navy involved. So if Malaysia commits war crimes in a war that Malaysia may enter into tomorrow, the people who may be vulnerable to an ICC prosecution will be the Prime Minister, the Cabinet, the Minister of Defense, the generals, but never the king. Never the king, because he's a constitutional monarch. I just give you an example. If all of you, you will remember when Tony Blair led the UK to that illegal invasion and war of Iraq in 2003, there were calls 1 or 2 years later to charge Blair and Bush. But forget about Bush. I'm not using the US as an example, because it's different, it's a republic. If you use UK as an example, all the calls to charge somebody were directed against Prime Minister Tony Blair for making the decision to go to war. Nobody ever in an English debate asked for Queen Elizabeth as the constitutional monarch and the supreme commander of the British forces to be charged for war crimes. And why is that? Because Queen Elizabeth is a constitutional monarch, just like the young di-Pertuan Agong. And that is how silly the argument is. But let me kill that argument with my strongest point, and I'll sit down now, which is where the British colonial powers from the 18th, 19th century, certainly since 1874, when they intervened directly in the federated states, they recognized the sovereign immunity of the 9 rulers, both nationally and also under international law. So the British were quite happy to say, we recognize the Sultan of Johor or the Sultan of Kedah, but they have the residence system, they had effective power, the British that is. Now that position continued when Merdeka was achieved in 1957, and the Constitution, the Federal Constitution, expressly provided in Article 181 that our rulers, the 9 rulers, the king and the 9 rulers, could not be sued or charged in any of our courts. And yet in 1993, those of whom you were here would remember, in 1993, the Constitution was amended and Part 15 was introduced into the Federal Constitution. And that meant that from Article 182 of the Federal Constitution set up the special court. So we have the special court which can try, and I quote, try all offenses committed by the Agong or the rulers and all civil cases by or against the Agong or the rulers. So that tells you that the Agong and the rulers are now, well, since 1993, vulnerable to legal action, both civil and criminal. And therefore, since 1993, they do not have immunity at all in our courts. But the only difference is they have a special court to hear them, whereas all of us are subject to the ordinary courts of the land. But what is forgotten is that the 8th schedule to the Federal Constitution was also amended in 1993. Now that includes provisions that the state constitution was amended, that when a ruler is charged with any offense in the special court, he ceases to exercise the functions of a ruler pending his case. And then if he is convicted of an offense and sentenced to imprisonment for more than 1 day, the ruler shall cease to be ruler unless he receives a free pardon. So that is how our law is today and has been for 25 years. Nothing to do with Rome, pre-Rome, post-Rome, absent Rome, absent Amsterdam, nothing to do with it. So that if the Agong and the rulers had already lost their immunity some 25 years ago under Malaysian law, and of course, if the domestic country, that's Malaysia, does not give them sovereign immunity, it is impossible for them to claim sovereign immunity in England. So let's say one of our rulers goes to England. In fact, it's an actual case in the 19th century, but even if one of our rulers goes to England and breaches a contract, he cannot now claim sovereign immunity. He'll be susceptible to a suit in London because the British judge will say, well, if you don't have sovereign immunity in your own country, don't expect me to give you sovereign immunity in my country. So they just don't enjoy it. That is the law. It is for these reasons that I had advised the government to ratify Rome. From a legal perspective, it would be difficult to argue to the contrary. Now, I am sure that my opinion on a straightforward reading of what is very clear law would be shared by the vast majority of lawyers who are trained or who are practicing in the bar or elsewhere. So I conclude by saying that the entire controversy of Rome is much ado about nothing insofar as the law is concerned. Thank you.